Afternoon, Mr. Sasso.
Nice to see you again, sir.
Good to see you all.
The way we're going to proceed today is we're going to go around and introduce all of ourselves virtually. And then you will have 3 or 4 minutes to make some opening remarks. And then we'll have a question and answer period. I assigned Commissioner Amanda Carl to vet you, and she'll start your questioning, and then I'll go through the commissioners. And then I will watch my clock carefully and make sure I hold back at least 4 or 5 minutes for you to make some closing remarks at the end.
All right, thank you.
Yes, sir. So with that, we'll proceed again. Welcome, Mike Sasso, Chair. Commissioner Carl is Vice Chair.
Good afternoon. I'm Amanda Carl, in-house counsel at A. Sons here in Oviedo, Florida. Welcome this afternoon.
All right, good afternoon.
Commissioner Andy Bardos.
Good afternoon. I'm Andy Bardos with Gray Robinson. I'm in Indy Atlantic.
All right, good afternoon, Mr. Bardos.
Commissioner Lauren Blocker.
Good afternoon, Lauren Blocker, in-house counsel with FIS. I'm in Ponte Vedra.
Good to see you again.
Commissioner Vincent Citro.
Good afternoon, Your Honor. Vincent Citro with the law offices of Horowitz and Citro in downtown Orlando.
All right, thank you, Mr. Citro.
Commissioner, is he still in court? We have one commissioner. I think he's still in court. David DeArmas. He may join us. Commissioner Craig Dyer.
Good afternoon, Judge. Craig Dyer. I'm from Daytona Beach, former Chief Assistant at the Public Defender's Office.
Good to see you, Mr. Dyer.
Excuse me, Commissioner Carrie Eisnagel.
Good afternoon, Carrie Eisnagel. I'm here in Sanford.
Good afternoon, Ms. Eisnagel.
And Commissioner Scott Thomas.
Good afternoon, Your Honor. Scott Thomas with the Burr Foreman Law Firm in Ponte Vedra Beach, Florida, St. Johns County. It's good to see you. It's been too long because of COVID, so it's good to see you in this format.
It has.
Judge, you have the floor.
All right, thank you. I'm going to be very short to start off with. My application, I hope, says more than enough. In fact, it probably says too much in terms of volume. So I appreciate you all having had a chance to read it and give it some consideration. I did rework it fairly substantially from the last one that I submitted about a year ago to many of you. And so I do appreciate if you had a chance to look it over. I want to address a couple of things right off the bat. Actually ends up with where Ms. Kozan stopped off at the end there. She was commenting about being young. I want to assure this panel that first off, I plan to spend, in fact, whether I'm on the circuit bench or on the District Court of Appeals, the remainder of my eligible working days as a judge. So I have about 15 years of eligibility, 14 and a share left to go. So it would be my intention to serve for the remaining 14 years that I could constitutionally serve. Second off, I'd like to point out, of course, that I have a wide range of life experience, and I'll address that hopefully a little bit through the interview. And finally, I want to address what's kind of been the elephant in a lot of rooms lately with regard to judicial nominations, and that has to do with someone's background or whether they belong to a particular judicial club or not. And I just want to share a short anecdotal story. In one of my first trials in the military, one of our soldiers showed up for trial, and he had recently put on his uniform a Ranger tab. There was nothing in his record that indicated he was Ranger qualified. And he came into court at Fort Benning, Georgia, which is the home of the Rangers, wearing a Ranger tab, expecting to show that off to the panel. I pointed out to the trial judge he wasn't entitled to wear that badge. And the trial judge instructed him that he had 2 choices: remove it or allow me to instruct the jury that he was wearing a badge to which he was not entitled. So I would just point out this and just leave this for your consideration. Whether somebody wears a tab, wears a badge, or joins a particular club doesn't say anything about them. What says about them is how they've lived their life and how they've practiced their profession and how they've exercised that profession. And that's what I would ask you to look at when you review all of the candidates here today. So whether they're a member of a particular club or society or group or party for that matter, I think it's more important to look carefully at what they've done, what they've said, and what they've written. And I would stand on my record any day of the week. So with that, I look forward to hearing your questions and addressing them.
Great. Commissioner Carl.
Good afternoon again, Your Honor. I had the pleasure of vetting you, and it was a pleasure. Your references had incredible things to say about you, and the caliber of your references is pretty incredible. The level of people that you have as your references it's pretty remarkable. I want to start off by kind of asking an open-ended question, and I asked this of a couple of your references about you. Your experience, your broad range of experience that you had with your military background, how would that carry over sitting as a judge on the 5th District Court of Appeal? Do you think that that would help you, or do you think that that would hinder you in your ability to carry out the duties of a judge on the 5th District Court of Appeal?
That's a very good question. I think it would help. And I think it would help for this reason. First and foremost, the background that I've been truly blessed to have, and I don't claim, and I've never claimed that I had any kind of life plan that put me first at West Point and then in the 82nd Airborne Division and then in the University of Florida for law school, the Army JAG Corps, and the various assignments that I had there and the folks that I was privileged to work with. I certainly had no plan for that. My plan was simply to live my life with my family and to serve my country. And all of that just kind of worked out. What that's done is given me a broad range of experiences to draw upon. I find it particularly useful right now on the trial bench, and I think it would be equally useful on the appellate bench to be able to look at the cases from both perspectives. When I'm sitting in judgment of somebody right now in criminal court and attempting to craft a sentence for them, the fact that I've worked with folks in all classes of society, the Army is truly a melting pot and a representative of the entire of our society. We have folks that came from families that have never had anybody that went to college. In fact, some of them, many of them never graduated from high school, all the way up to and include the most highly educated folks. So I've had a chance to work with people at all levels of experience and learn from them. And every single one of them was a learning experience. And I think I would bring all of that to the 5th DCA. And then secondly, the time I had in the Army, both as a line officer, first commanding troops, and later on being a legal advisor to commanders, also gave me a very unique perspective. In the Army, as a staff judge advocate or as other legal advisor, you are the general counsel to the commander. You have to know their business. You have to get into their business. You have to learn it deeply. And I've done that. I've done that in every case. In fact, I do that probably too much in every case now, getting way too far into the details, at least some people would say. If anything, that's one thing I have to kind of unlearn, perhaps on the appellate court, is not trying to read every single detail of every case. But that's what it's given me, is the understanding the necessity of getting into the individual facts and cases and understanding what they all mean and understanding the people.
Thank you. I appreciate that. My next question, on page 7 of your application, where you talk about that you have served as an associate judge on the 5th DCA, and all of those cases have resulted in PCA decisions and no written opinions. So my question here is going to the PCA. And if would you have preferred in any of those cases that a written opinion have been issued? And as a follow-up to that, in your opinion, what would justify issuing a PCA, and when should a written opinion be issued?
It's a great question. Of course, we all know the reputation of the 5th DCA, the 5th PCA. As a trial judge, I love it. I'm just kidding. The reality is, I think it's a very important tool. And actually, in the time I sat, the 3 cases that we had, we sat down and we very carefully discussed all of them. And one of them was close to having a possibility of an opinion. But quite honestly, when the 3 of us sat down, and without getting into the details of the conversation, when the 3 of us sat down and we talked with each other about the case and about the precedent cases. In fact, it was the one that was assigned to me to potentially write. I could have jumped up and said, hey, I'm an associate judge. I'd love to have something out there in writing. But I don't think what I would have had to say would have added anything. And I think that's the time when the courts need to be very careful about not writing. And that is when there's nothing to add you're just going to confuse the practitioners. However, on the other hand, when there's something very important to clarify, when there is truly a decisive point that hasn't been completely explored, I think it is important to write. And I think it's important to write at the necessary length to get that fully across. I recently had my first overturning. I provided you all with that opinion. And with all due respect to the judges, several of whom I know, at least on somewhat of a basis, I wish they'd actually written some more because I still don't completely understand exactly what they were trying to tell us. I understand the superficial, I shouldn't say the superficial, the top level issue. But I think there was some subtlety in the case that needed some further analysis, and I would have liked to have seen a little more. I don't know if that case is going to get appealed up to the Florida Supreme Court. I doubt it. But we'll come back and we'll see, because it'll be back in my lap since it's been returned to me. But I think PCA is a critical tool to not clog up the Southern Third with just plain words that have no particular meaning. To simply say, we agree with what all those guys said before us. You can say that with PCA. And secondly, as a trial judge, I will tell you there's one other reason I like PCA. It should be used when you think the trial judge got it right. Because if there's nothing more to be said from what the trial judge said, we certainly appreciate it on this end, and I think all trial judges do, to be told that yes, you're not only did you get the facts right, which is ultimately our job as a trial judge, but secondly, you got the law right, and I appreciate that.
Thank you. And I have one more question, and then I'll pass it along. You were here with us a little over a year ago. I think it was August of 2019 that you were in front of us. Have you done anything differently since then? Have you changed anything that you think would improve your chances in front of us this time? Is there anything you can tell us about?
Superficially, I shaved off my beard.
Hey, most people in COVID are getting them longer, like my husband, so.
No, actually, I had that a year ago. I actually was wearing that beard in honor of the late Judge Clyde Wolf. November, No Shave November is supposed to be about men's health, and he ended up dying of a cancer that was related to men's health. And so I wore a beard for a year in honor of him. And then finally, about October of last year, my wife decided she'd had enough of my beard, and so away it went. But no, yes, I have done some things. Obviously, I've made a few connections with some individuals that may be able to assist me when the time comes. But more importantly, I think I've done more to study the craft of writing. I've actually really spent some time on that in the last year. There are some great writers out there. Some of you are appellate practitioners, so you may be on the so-called appellate Twitter. And there are some folks that make comments about writings, both some judges and some practitioners. And I've really focused on that. And I've really focused on my writing and on my analysis in my orders. And hopefully that shows up. I think 2 of the orders that I gave you, at least one I know is definitely different. And I will tell you all 3 of the orders that are in my sample writings, all 3 have been appealed. One is the one that was just overturned, but it was a very careful analysis. One is on appeal right now on a writ of prohibition on a stand your ground case. And the other one was upheld. Well, actually, I'm sorry, it was dismissed on by one of the parties in view of it was about to be upheld, I think. So, but that's what I've done is worked on my writing skills and the ability.
Thank you so much. Thanks for being with us today.
Thank you.
Thank you, Commissioner. Commissioner Andy Bardos.
Judge, good afternoon.
Hi, Mr. Bardos.
I'd like to start out with something you pointed out in your opening statement, and where you said, if I understood it correctly, that we should put less weight on labels and club memberships and more weight on what people have done and said and written. What would you point us to among the things that you have said and done and written that would give us insight into your judicial philosophy?
The 2 of the writing samples that you've got there in the tail end of my application have some specific points. One dealt with, and actually I've got it up here on my screen. So the one advantage of us being on Zoom is that I can actually look at a document at the same time. One of them was in a case involving 2 same-sex partners that were seeking child rights over one child. And the one who was seeking the rights had never been married to the other. The one parent had adopted, the other had not. And that person was seeking to obtain judicial approval, or first actually a declaratory judgment that she had rights over the child. And as much as I might feel personally for the plight of her and the child and the fact that they have an emotional link, I came down straight on the law. And the law in this case, notwithstanding even Supreme Court precedent about marriage, which this really had nothing to do with, was that the unmarried other parent has no legal standing, for that matter, to actually bring forth a lawsuit of this type. And the advocates on both sides were both very strong and were both seeking to push some rights that, quite frankly, just don't exist right now. And those rights are clearly part of the legislative mandate. I'm going to touch a third rail here. Obviously, there's been a lot of discussion lately in the press and otherwise about the confirmation of now Justice Barrett and her thoughts on Roe versus Wade in particular. I wrote about Roe versus Wade in law school. Spent a lot of time studying that opinion. And regardless of what I think on the merits of the underlying issue, and I do have some strong thoughts in that regard, the opinion did something terrible, and it had nothing to do with the constitutional outcome. It took a question that was being decided in the political sphere and was being decided by the various states and took it out of their hands and made it into a federal case. And I think if a lot of us study that case very, very carefully, you would see some of the flaws in the precedent. Now, I'm not saying it should be overturned. That's a whole different story, and that is echelons above my pay grade. But that's the way I look at cases very carefully. I am very cautious about the mandate to the legislature and to the courts. Secondly, you talk about said and done. I had a case which came forth actually after this application was submitted, and it involved actually doing an order to show cause to order the Department of Children and Families to show cause why they had not taken custody of a prisoner, transported him to the state hospital. And the DCF's opinion, or DCF came back and said, well, we've suspended that obligation. And I wrote in my order to show cause an 11-page analysis of the statute involving commitment of prisoners to the department. And in that analysis, I said, it is not my place as the judge to tell you as a state agency how to do something. That's where separation of powers kicks in. But it is my place as a judge to say that the legislature has created a personal right in this individual that has to be fulfilled by the DCA, or DCF, I'm sorry. The DCF took me up on a writ of prohibition. As luck would have it, the Department of Children and Families decided to transport this individual to the state hospital about 3 hours before the hearing was to be held. And so ultimately, about a half hour before the DCA in the end ruled, I dismissed the order to show cause. But the order came out last Friday, and the order said that the writ of prohibition that the Department of Children and Families tried to bring was dismissed on the merits. That in fact, I think I had gotten it right. And my analysis was very careful. I was not trying to tell the DCF how to do their business, but there was a personal right that was at stake. And that personal right, I couldn't even tell them how to do it. My order said, you come back to me with a plan and tell you how you're going to do this. But it's my job to say what is the law and what is an obligation, not to tell you how to carry it out. I hope that answers your question.
It does. Thank you, Judge.
Thank you.
Thank you, Commissioner. Commissioner Lauren Blocker.
Hello. I just had a question about your writing process. I noticed in listing orders that had been reversed, you mentioned one where you said, be careful of an order written by counsel. How can you explain how, like, your reliance on proposed orders and how you might, reverse course and how you would prepare an order on the appellate bench?
Yeah, obviously, we don't ask counsel to prepare orders for the appellate bench. The process, as I learned very well, and in the process of being an associate judge last year, is very good. Outstanding law clerks work and prepare a bench brief for the judges. And that bench brief often becomes the core of a written opinion in the end. I do a lot of my own writing. I don't actually use our law clerks here in the trial court very much. And that may be good or bad. But I do a lot of my own writing. I just tend to start writing from an analytical framework of what does the law say? If you look at my orders, they tend to follow the same pattern: procedural posture. What is the law that appears to apply in this case? What are the facts? And then conclusions of facts and law. I think it would need to be, I'll need to be shorter on the appellate bench. As I said, I think my orders are too long right now. But that's how I go about it, is I try to study the law very carefully. I spend a lot of time doing my own research, both Lexis and Westlaw subscriptions. Thank goodness we have both of them. I'll dive into both heavy and run down several trails of case law in order to make sure that I'm getting it right and understanding the background of the case law.
Thanks. That was my only question.
Thank you.
Okay, thank you, Commissioner. Commissioner Vince Citro.
Your Honor, have you had occasion to reject any negotiated plea agreements while sitting on the criminal bench?
I've had two.
Tell us about them, please.
Yeah, in both cases, I didn't actually end up rejecting them in the end, but when they tried to present them to me on the surface, I was very much resistant on them. One involved somebody who was involved in drug distribution, and it was very much it appeared to be very much a sweetheart deal, and it just made little or no sense to me on the surface. And so I asked the counsel to please delve in a little bit more and give me a little more detail on why in this particular case I should do that. The other one, I believe, involved a convicted sex offender. And once again, I was not comfortable with the posture that they wanted to leave the case in terms of it being purely, I think, purely a probation case. Again, I needed to delve in a little bit farther and get them to explain a little bit farther why they wanted to do it. And I will tell you, in that second case, ultimately, the reason that I ended up acceding to it was really twofold. One, I believe there was a significant weakness with some of the elements with regard to the victim. And secondly, perhaps more importantly, a very young victim, very vulnerable and very much at risk if she actually went and testified. And so the state felt at that point and was able to convince me that there was no merit in them trying to go forward to a trial, and they had to get this individual to agree to these terms. But I have pushed them on it. Quite frankly, most of the time, the state has a very good offer when they finally get to it. We've been seeing a lot more, obviously, settlements during the COVID era. We're getting ready to have our first jury trials next week, finally, first ones in 6 months in Putnam County. And the state has made some good offers. And unfortunately, I'm also seeing a lot of those folks come back on violations of probation. So, but those are the two that I put a stop to and said, whoa, you got to convince me. This just does not make sense.
Okay, thank you. That's the only question I have.
Thank you.
Commissioner Craig Dyer.
Good to talk to you again, Judge.
Craig.
Just curious about the public defender who's working with you. How are you getting along with them?
We have a phenomenal team in Putnam County. I wish it wasn't changing. Unfortunately, with the change in the electeds, things happen and things change. We had an outstanding team. I think we're building a new good team. I have very good, a lot of trust in the public defenders. This morning I had somebody try to raise a Nelson issue with regard to one of our public defenders. And I asked the gentleman intentionally in this case, I usually like to hold Nelsons to the end of my docket because I don't want all the rest of the prisoners to hear what it is they're raising on a Nelson issue. Nelson, of course, is I want to get rid of my lawyer because he's incompetent. And the two bases that this gentleman raised, I knew were going to be, I suspected were going to be off the wall, and they were. He confirmed it. And so I made it very clear to him that his public defender's job was to give him the unvarnished truth. And that appears to be exactly what his public defender was doing. Got to be careful not to sound like you're prejudging somebody, because of course I'm not the trier in most of these cases. But very, very good team, a very strong team in the public defender's office in both Putnam and St. John's. I work with the St. John's folks as well because of Veterans Treatment Court. So I still straddle both counties.
Going back to that issue of the PCA, it's my understanding the reason why there's a PCA is because this is established law. There shouldn't be any room for argument. This is the way it's supposed to be. Well, would you not agree that there should at least be a cite to the law in the PCA so that there's no argument?
Well, as you know, if you do that, if you put anything other than PCA, you open the door to your 7 friends in Tallahassee getting to review the case. I think it would be more useful, quite frankly, and I'm going to sound like I'm patting myself on the back, and I'm not a fan of that. If more judges did like I did and they cited the law in their opinion and their order that they write at the trial level, because then the appeals court just has to say PCA. If somebody goes back and reads the order, they would see the basis for it. That's the problem. I guess if you were to include a very short citation, that would be useful. In fact, I'll candidly admit here, that case that came out on Friday, the 5th DCA said more than PCA. They said the writ of prohibition was denied on the merits, and then they gave a citation. And so, being the inquisitive lawyer / judge, I went and read the citation, and it explained to me exactly what they were saying. So it can be useful to do that, but perhaps that's an issue on the appellate courts and the appellate rules to try not to open things up for a full appeal just because you say, here's the case I was looking at. Of course, if that case was wrong, or if that case is later overturned, that gives an adequate basis to go back and change it over. I can see both sides of the issue, but I think PCA has an important place, perhaps a little overused, but it has an important place.
Thank you very much. I appreciate that. I don't have any other questions.
Thank you, Commissioner. Commissioner Carrie Eisnagel.
Hi, I'm new to the commission, so I just wanted to get a deeper understanding of how you determine the meaning of a statute.
Very important. Obviously, you start just reading the doggone text. And I didn't make that up. A friend of mine who was in the Army, who's an appellate judge, and I were talking one time back before I retired, and he said, it's amazing how many lawyers just haven't read the doggone statute. So just start with the statute. If it's clear on its face, you're finished. If it's not clear on its face, or if there's some factual ambiguity that comes up in the case, then you try to determine exactly what the statute means from the 4 corners of it to start with. And only if that becomes totally frustrating and you've ruled out using any of the appropriate rules of construction, do you start looking at things that might help you, like documents that were passed contemporaneous with the statute. I've actually found reading the changes in the statute to be very important, because that tells you almost as much as what the legislature meant just by the fact that they changed some very important words in the statute. We have one right now. I tell you, there's one right now that we're dealing with in criminal law, in probation, where the statute is patently ridiculous the way it is written. I don't think the legislature meant to say what they're doing. They said it's in 948.06, I believe, because it gets quoted to me quite often by defense counsel. Sorry about that, Mr. Dyer. But it gets quoted to me, and it says something along the lines of, if somebody is on probation and they violate their probation, then if any of the following conditions, and that's what it says, if any of the following conditions are met, the person can be reinstated back to probation. Condition A, the person is on probation. Of course they're on probation. They violated probation. It clearly, by reading the statute, it clearly had to be either an all or additional qualifier. I don't know how it slipped through the legislative process, but it did. And so that's a case where you look at it and you say, well, the statute as plain text written has a clearly ridiculous meaning. It couldn't possibly mean that. And so you have to go beyond that. So you have to be careful about going beyond that. And obviously then case law becomes a huge important factor when you get past all those other steps of the analysis to see where you should go.
Thank you. I don't have any other questions.
Okay. Commissioner Thomas?
Yeah, thank you. Your Honor, how many times have you sat as an associate judge on the 5th DCA?
It was just one time, unfortunately. It was about 2 years ago. Got to sit on a panel with Judge Lambert and actually Judge Eisnagel. And we had great oral arguments. I thoroughly enjoyed them. One challenge was we had a lawyer who showed up. The other side never showed up. And one of the two, and the other lawyer decided to get up and still present his whole oral argument. We're kind of sitting there going, you won.
My general rule is if you're winning, be quiet. So yeah. In terms of that service, I wanted to follow up. You've had some questions and talked about the PCAs, and I agree that the prudential concerns about writing too much. Does that apply to dissents? Does every disagreement merit a written dissent?
No, not everyone does, but I think it is important. The purpose of a dissent is to show where there is a fracture in the law, where there's some context that may be missing, or that where you as the one judge who's dissenting has not been able to persuade the other judges on your panel to see that particular issue. It is very important if a case is going up for higher review, I think, to outline that. But the other thing you always have to keep in mind is you're writing a dissent, you're not writing an advocacy piece. Although you may have a particular view on the law as an appellate judge, in the end, it is your view. It's not your case. And although we all take some personal pride in our writing, in the end, the case belongs to the parties. And if you're going to write a dissent, it needs to be very respectful. And it needs to be very clear that you just disagree on this one particular point, and you think that point is significant, particularly in a DCA where it's a 2-to-1 vote, because you only have to convince one other person to change the situation.
Sure, and I guess if it's a question of first impression or relatively new, you've got 4 other DCAs who you may want to provide info for their consideration, I would guess.
Absolutely, absolutely. And you know, as a trial judge, I'm looking constantly at cases from other circuits because, believe it or not, everything has not been solved by the Florida Supreme Court or the 5th DCA. So we get to look at the other circuits a lot. And I've already developed a few of the judges in the other circuits that I like. Actually, one's a retired one, Judge Altenberg. I love the way he used to write, at least. He was a great writer on his opinions. And our current Chief Justice is a great writer. I love reading his opinions. Because they're so clear to me, and whether he's in the dissent or the majority, I understand exactly where he's coming from.
Well, thank you, Your Honor. I don't want to cut into maybe your closing time here. So it is good seeing you, and thank you very much for your presentation today.
Thank you.
Okay, Judge, that will conclude the question and answer portion of the interview, and this is your opportunity to make some closing remarks.
All right. Thank you again for your time. Appreciate the opportunity to meet with you all. Interestingly enough, one of the things that a couple of the other folks who interviewed today or tomorrow and I talked about was what background to use, whether it was appropriate to use our judge background in our Zoom setting. And I decided I was going to just be me. What you see behind me is my home office. And you see a lot of the things that make up my past without me ever having intended it to be that way. What you see behind me is what is me besides the law. The blanket from my bed at West Point, the black, gold, and gray stripes on it. The St. Augustine lighthouse right on top of the piano. The bass guitar hanging in the corner, and the Florida Gator standing on top of the piano. So those are the things that light me up when I'm not in court. I like doing music. I play choir for my church, 2 different services. I love spending time with my kids, and now our one young granddaughter who's actually over here today. I can hear her in the background. Hopefully she hasn't been coming across to you all. Those are the things that inspire me every day to go to work and to be a judge and to serve the people of Florida and to render the best possible decisions that I can, being true to the law, being true to my own background as an Army officer, being true to West Point's motto, which I wrote about in my application of duty, honor, and country. Those really are what make me tick. And I really would look forward to the opportunity to serve on the 5th DCA. I said I would be interested in serving for 14 years. Of course, the man upstairs has the ultimate ruling on that, and I don't mean Governor DeSantis. However many years I'm granted, I'm planning on staying on the bench to continue serving because I think I have something to offer, and I think I have something to contribute to both the law and to our society. So thank you very much for your time. I appreciate your attentiveness, and again, reading all those 100 some odd pages that I submitted.
Judge, thank you very much. Thank you for your service to our country, and thank you for your current service as judicial officer.
Thank you very much.